Welcome back to Over 55. I'd like to introduce David Fischer, who is a partner at Lerners. Hello, David. How are you?
Fine, Ron. How are you doing?
Great, thank you. Interesting subject today, and I think people will take a lot away from this about wills and powers of attorney.
There's a lot to take from this subject.
Well, this is good. I've known you for probably 6 years or more now. We met by chance. I had you do my will, so.
I'm glad you said that. I can't. I'm not allowed to say that.
Well, thank God I'm still here, and you taught me.
We wouldn't be doing this without you.
That's true. It would be in effect right now.
Yes.
I think there was a lot that you taught me or showed me about wills that I didn't know, and I already had a will for years before I came and saw you, and you added a lot to the will. So maybe you can say, well, what's the main reason why somebody should have a will?
Well, the main reason why is if you don't have a will, the government is going to make a will for you. There is a section in the Succession Law Reform Act which provides for what happens if you die without a will. And you really don't want the government determining what's going to happen with your will. Another significant factor is you want to make sure you choose the person to look after your estate whom you want.
Correct.
That's very important.
Right, yeah. I don't like the government controlling what we do. That makes sense. And I guess with a will, and then at least you can set it up at the beginning, right? You know what you're going. You have possessions, loved ones, friends that you would like to give something to, and rather than having the big fight at the end when you pass away.
Well, that's right. And actually what happens is if there are any unresolved matters with the family, you can be sure that they will be coming out either at or during the funeral. I mean, I remember one case where during the funeral, one of the deceased's children took a moving van, backed it up to the house and cleaned out all the insides of the house, just the whole content.
Well, everybody was at the funeral.
Everybody was at the funeral.
Oh, wow! So they sort of had their affairs in order.
Which means too, you might want to consider changing the locks in the house.
And people, I know the finality of death. It's a final thing that we all going to face one day.
100% of us will die.
100%, very good.
We just don't know when.
We don't. That's correct. So it's important that we line up. You know, especially if people have children, for example, or they have heirlooms, and somebody should get the brooch or the pin, and somebody gets the car. 2 properties. I guess that's also. There's a lot into a will.
Well, actually, personal effects, just mementos, souvenirs, things that really don't have a large monetary value can be the subject of a huge fight. I mean, if 2 family members want the same article, how do you determine who gets what, or if it just should be sold and the proceeds divided up? Another big area of division is the family cottage.
Oh yes, that's true.
If that's been in the family for many years, who knows if that'll continue? I mean, you always get somebody who promises to contribute to the cost of the cottage, but after death, inevitably that doesn't happen.
Yeah, it could be 2 children or 3 or 4, and somebody wants to keep the cottage because they've been going to the cottage all their lives, and the other ones just want to sell it because they're tired of going to the cottage and they want the money. So
that's right.
This is the things that have to be determined by, I guess, the person that owns the cottage prior to.
And then you have the situation where you've named more than one executor and they don't get along.
Oh.
Now that is really, really difficult because if nothing gets done.
And some people might not know you can have more than one executor.
You can have 1, 2, 3, you can have 35 executors. Mind you, I don't really recommend 35 executors. No. It's a little bit time consuming.
But I guess the important thing is to get your affairs in order.
That is the most important thing. And don't leave it until the week before you pass on.
Right.
That can be very expensive for one thing, and also that can be the subject of somebody contesting the will.
Yeah, it's unfortunately everybody can be friendly until the person passes away, and then there's all these possessions, and it might be your best brother or your sister or a family member, cousin, or just a friend. And when it comes time to divvying it up, it probably goes into the courts for years that if you contest something that you felt you should have versus what I thought I should have, nobody wins. I hate to say but the lawyers, but I guess the government
that's true.
as well.
Well, and if you don't have a will, you're really allowing the government to dictate what the income tax consequences of your estate are too.
Yeah, I bet you people
Because
don't know
people
that.
don't plan to save tax. They don't plan to save probate tax, probate fees. They don't plan to save administration fees, legal fees. Legal fees are a necessary evil. You hear that from a lawyer.
Right.
It's a necessary evil.
Okay. We're going to be right back with David, and we're going to go into talk about powers of attorney, which is another part of the will section. So we'll be right back in a few minutes. Welcome back to Over 55. I'm here with David Fischer from Learners. We're going to talk about power of attorney, which goes hand in hand with the will side.
They really do go hand in hand. It's easy in some respects to sell a will. You know that somebody is going to die. You're not certain that they're going to become incapable of making decisions. But our bodies were made to actually break down. We're living longer. In some respects, we're living healthier. But we do wear out, and you want to make sure there's somebody there to make decisions for you in case you can't.
Okay, and that's important, that part where actually you told me about if I'm on a life support system, for example, and I don't want to be.
It's possible to cover that on two levels. First of all, you can name a person, a proxy, an attorney, not the American term, but somebody acting under a power of attorney, who can make decisions for you relating to your personal care, your hygiene, your safety, where you'll be housed, and also make a living will, which is just a do not resuscitate order, basically, which says that if you're only being kept alive by artificial means, you want that to be discontinued and you want to die only with the administration of something to keep you comfortable.
Right.
So that's a very important document.
Yes, and I think you told me years ago, which I thought was great, that this is, since it's in the document form, the stress isn't really on your loved one or your caregiver or wife or spouse or whoever that may be.
Or physician.
Yes.
Because the physician is protected if that is specified.
So that's very important. I don't know if a lot of people know that, and to me it was a great knowledge in that my wife won't have a stress of tripping over the cord, we'll say. I hope. Now,
not on purpose, I hope.
Yeah, not on purpose. We do get sort of klutzy as we get older. But
that's a bit much.
But also property power of attorney.
Yes, you can have a general power of attorney, which is called a power of attorney for property, which will you can name someone who can make decisions for you related to your property. You can have a limited power of attorney, which can be used, say, to sell your house or to sell your boat or act for you when you're out of the country. But it's more common to have a power of attorney for property which is general in form.
Now, power of attorney could be anyone, family, non-family, young, old?
It can be, but it has to be someone whom you trust.
Okay.
Yes, you can have somebody responsible, but if they don't have any assets, it really doesn't help you very much.
Right. So it's something to check out, just looking at whether it be the health side or the property side, family. A good thing to sit down with your family and maybe go over your thoughts of as you're going to pass, because we're all going to pass.
Well, I think that would avoid a lot of the disputes that we see. We see very expensive disputes. We had one case where there was a will which was changed by people writing on the sides. They just made handwritten changes to the will. $41,000, and 3 years later, the matter was actually settled.
So that's probably not the right way to go.
No, I don't recommend it. It contributes to our pension plan.
Yeah, if you've ever seen Learners Building, you'll see what David means. The other part is a codicil. So you can have a will for a few years and buy a new cottage or piece of jewelry, and you can add a codicil to your will?
A codicil is an amendment. It's read together with your original will, and the two are read together. So The original will keeps in effect except to the extent that you change it with the codicil.
Okay.
So usually it's only a minor change or changes.
Okay, so it's minor. You don't have to sit down and redo the whole will again. It's
No.
just it's an addition, like you say, to the will.
It's a change.
Okay,
yeah.
so
or
depending,
an addition. It
okay.
can be both.
but depending on the size of it, I guess, or how long should? I guess another question is, how often should you review your will?
I suggest every 3 to 5 years. I sort of favor every 3 years.
Okay.
Because people die, people move away, there's a divorce, there's a separation. You're no longer friends with the individual. You just don't trust them anymore.
Yeah.
So there are all kinds of reasons why you would do it every 3 years.
Okay, and that's a good time frame, because I think some people make a will, stick it in a drawer, and forget about it. Now, your office keeps a copy of the wills on file.
Normally we keep the original will. It is your property. It belongs to you the moment that you sign it.
Okay.
But most clients seem to prefer that we keep them on file in our vault so they don't get lost.
Okay. I guess a question that I've always thought about for years. Say my wife and I have gone somewhere across the world. We both die. How do you know? I mean, we don't have any family. We're very hermit-like. We don't have a lot of contact. How does people know about this?
Now that's a very good question. At some point, somebody is going to become aware of your absence.
Okay.
But there is no, it is possible to register a will, but that's uncommon.
Okay.
So it's just somebody becoming aware, whether it's a friend, a charity with which you're involved that no longer has a contact with
right.
you. But these things sometimes aren't known for some time.
Yeah, because I was going to say, I gather the bills would pile up, and maybe the hydro would say you haven't paid your bills, so they might send somebody to cut your electricity off or something. But I've always wondered, is there a bunch of people in the lawyer's office going through the obituary saying, "Oh, Bob Smith passed away today"?
Sometimes that's right.
Okay, I was just curious because I've always thought, how would somebody know?
We generally check the obituaries,
Okay.
just so that we
Right.
know.
Anything else you'd like to add about wills and power of attorneys?
Well, just that about 52% that's the latest statistic I've seen. 52% of adult Canadians do not have a will, and I don't know what the statistic would be for powers of attorney. I would suspect it's more like 70 to 80%.
That's huge.
It's huge, and it holds up the estate. It's expensive, it's time-consuming, and it's really anguish, causes a great deal of anguish for families. So that's why you should do it, and not as an insurance policy, but as just out of consideration for your family and friends.
Okay. Steps to get a will? If somebody said to watch the show and said, I think I need to make a contact and get a will.
Call a lawyer if you have a lawyer whom you trust. I think that's very important. If not, I mean, we would certainly be happy to help you at Learners.
Okay. Any kind of documentation they should bring in with them, like a passport or ID of some sort, just to make sure
You do
they
need
know who they
ID whenever you see a lawyer.
Okay.
Because you need it to open the file. So a driver's license will be sufficient. Any picture form of ID is necessary. A list of what your assets are.
Okay.
Copies of your relevant documentation, your investments.
That's on the first visit, because sometimes it might take a second visit, depending on the size of the estate.
Quite often it does take a second visit.
Okay.
But those are more of the common documents that you would bring.
Okay. In summation, anything just burning that you'd like to say about wills and power of attorney?
Well, just that don't try to do this yourself.
Okay.
Because quite often wills have to be signed a certain way, and quite often they're not signed. For example, the two witnesses aren't present at the same time; they're present at different days, and that invalidates the will.
Okay. Well,
So
thank you.
Please be careful.
Okay. Thank you, David. Really appreciate you being on. People should get a hold of David. I know there's crawlers underneath, and David's excellent at doing what he does. Just a quick minute. Tell you about next week's show. We're going to come back with the home reno with Kathy Smith. I think we'll show the before the during and the after. Kathy's just unpacking some boxes now and trying to settle into her new home. So we'll see you next week. Thank you for tuning in to Over 55.